on for a review of compliance with the evaluation, Mr. Gilbert? I don't see anything in my file, so let me start with Mr. Lawrence and then I'll come to the parties.
Your Honor, I checked with Odyssey yesterday and I again found nothing there. I have received nothing through email for Mr. Gilbert. And so my assumption is that he has not complied yet.
Okay.
I have a date set.
Oh, great. What is that date?
November 28th. It's a Tuesday.
Okay.
I
And
didn't know I was supposed to apply with everything else. It's with the Dr. Stevens or whatever for the psychiatric evaluation.
yep, the psychological evaluation. Okay. You said that's November 28th.
Yep.
Okay,
It's a Tuesday.
great. So
Can I
it'll,
ask?
oh, just a second, sir. Hold on. I'll come to you with any further input or questions. Let me just do the basics we need to get done. If that's going to be on November 28th, it will likely take some time to get the report to the parties and have a chance to review it. So I would recommend we come back. I know this is during the holidays, so I don't know people's availability. We could do December 20th or 27th, or we could bump it into January. Mr. Lawrence, what's your schedule like?
My schedule is free, Your Honor. However, my experience in working with Dr. Maharg is that his initial appointment is going to be like a clinical interview. There may be a separate date for him to do testing. And then there's going to be collateral interviews with Dr. Maharg. And so my suggestion is we wait into January in order to get all this stuff together.
Okay. Mr. Gilbert, did you want to say something?
Yes. Is there any way I can see my kid unsupervised? I mean, I do not understand this. I've got nothing in my past, nothing in my history, nothing at all that says I can't be around my own son. I mean, the stress this has caused and everything. I'm not working right now. This has caused ungodly stress on my life, my work, everything.
Mm-hmm.
I mean, at first I was not telling anybody about this because being branded an unfit father that can't be around his kid, but
Mm-hmm.
it's just gotten to the point it's unbearable.
Okay. I will comment on that after I hear from Ms. Gilbert. Go ahead, Ms. Gilbert. What's your input on, I guess what Mr. Gilbert just said, but more importantly, if our follow-up court date in January works for you? I'm looking at probably January 17.
Yes, January totally works for me. I do want to say, I just want to make sure that he is getting the right test, like the drug test. He did not do the right thing. So I just don't want to come back in January and find out that he did not do the correct evaluation. So anyways, but yeah, as far as unsupervised visitation, I'm still a hard no if possible. He has done nothing to comply with the court, basically.
Yeah. Here's going to be my ruling. I am going to set our review date on the psychological evaluation completion and report to January 17, 2024 at 9 a.m. I, at this time, am declining to revisit or revise visitation. I think what the court has put into place is appropriate under the circumstances and facts in front of me. I disagree, Mr. Gilbert, that there's nothing in the file to support the type of visitation we have put into place. So I am leaving it as is until we get the results of the psychological evaluation. And further input, I think you'll remember from my August bench order that I did also have concerns about the living environment with which the child had been exposed to in your home. So I'm going to leave visitation as is through January 17th review date. Anything else the parties need from me?
I would like to know why the court's recommending this.
Sir, I've already made my record in all of my bench orders. We've talked about this numerous times. Every time you've been on, it's been like pulling teeth to get you to do the evaluations the court has asked of you. So I'm simply, I've issued my ruling. Visitation stands as is through January 17th, our next review date. I'm very glad to hear that you have the evaluation set up for November 28th. And I wish you the best of luck through that process, and we'll talk again January 17th.
Thank you,
Okay.
Your Honor.
Thank you.
Thank you.
All. You're free to log out. I show as we're simply here on a review, kind of where we're at with regard to the remainder of the dissolution proceed payout.
Are you asking me?
Yeah, it looks like Mr. Westleen, that there was retirement account issues that were still outstanding. It looks like Ms. Westleen had been given some paperwork to fill out.
Yes. As far as paperwork, everything's been submitted. She has an account where the money is supposed to go. We're just waiting for the money to show up.
Okay, Ms. Westleen, sorry, you're muted, ma'am. You might, if you're on a phone, click *6.
There we go.
Okay,
Can you hear me now?
I can, go ahead.
Okay. He told me yesterday he has some papers I have to sign for that retirement account.
Okay, and you haven't done that part yet?
He just told me about it yesterday. So.
Oh, okay. Do you want to go ahead and just set this over for a review in about 30 days?
Yeah, it sounds good to me. It should be through by then.
Okay, let's set this to November. Do you want the day before Thanksgiving or do you want the week after Thanksgiving?
Ask him.
Mr.
I'll
West,
leave it to his
what's
court.
The week before will be fine.
Okay, so let's do it's the week of, so it'd be November 22nd at 9 a.m.
Okay.
All right, that's okay with me.
Okay.
November 22nd?
Yep.
Okay.
All right, that'll be the new review date and we'll see where you all are at that time.
Okay, thanks.
All right, thank you both.
You have a good day, sweetie.
You too, thank you.
Bye-bye.
On for temporary parenting plan review, where are the parties at?
You know, I feel like a lot of stuff came up. You know, I almost backed out and I thought, you know, the plan was that eventually we were going to get to a comfortable point where it would just be 50-50. We both agreed on no child support. So I had submitted those. I had concerns about drinking and driving with my daughter in the car. And I just requested that if I have any concerns in the future, that I'm able to request a UA. But other than that, I'm okay with the 50-50. I did get served with her paperwork and I'm not okay with that because I don't feel that that is 50-50. I like my time with my daughter, and like my schedule with my daughter is, you know, I get off work, I go, you know, through the whole routine. We hang out, feed her, eat dinner, I bathe her, I put her down for bed. I mean, I'm just doing this with my mom. Occasionally she sees her auntie, but I feel like we really have a good thing going on, and I don't want to have to go to her mom every night and drop her off at her mom's or have her mom pick her up. I kind of prefer to not have that much contact with her mom, and I just really feel good about what I have going on in my 50% of the time and don't want to give up any more than that.
Yeah, I did just see, so when I actually reviewed this yesterday, I did not have your proposed parenting plan scanned into the file yet, Ms. Davenport. So I haven't had a chance to look at it. It looks like it was, you filed it on Monday. So it's available to me online today, but it wasn't yesterday when I reviewed this case in preparation. So I haven't been able to see where you all disagree. specifically, but it sounds like we're not quite at agreed order place. So let me ask the two of you this. You've never had a guardian ad litem appointed. That is, you've probably seen them online where they interview both of you, other people involved in the child's life, and make recommendations to the court. Is that something that you would be interested in having involved in your case?
I would rather not if possible. So with me, I'm for 50-50 because I feel like that's the best thing for our child, to have equal time with her dad and me. It's very healthy for her and she's safe with both of us. My only concern is I was asking for first right of refusal, because Adeline,
First right of refusal in this, what does it mean to you?
from my understanding, when it comes to custody, would be that he would call me if he needs childcare first. So instead of Adeline staying at her grandma's during Greg's days, he would still get his time with her, and then she would just be with me during the night instead of staying those nights at his mother's. And I want her to have a healthy relationship with his mom, which is her grandma. And I see how this is affecting my daughter and her relationship with his mother. She's really upset. She doesn't understand why, if she can't be with daddy, why she can't be with me. And it's really affecting her. And I feel she's 4 years old and I feel like she needs to be with her dad and me. And that's where she wants to be. So I don't understand.
So typically, I rule that in these types of situations, absent extenuating circumstances, that the parent whose residential time it is gets to decide who is watching the child if they have to work or do other things. So I don't typically grant what you are calling first right of refusal is not something I typically grant. Here's my recommendation. You all appear to be close, but again, because your proposed plan was just filed, I haven't had a chance to sit down and fully compare them. I would recommend that we transfer this to mediation, have you all meet with a mediator to go through your differences and see if you can bring back an agreed plan to me rather than doing a GAL. Would you
How
guys?
much does mediation cost?
Let me pull it up. They just told me it's not much. Well, it's way cheaper than a GAL. I do know that. Okay. The charge per mediation, and it's done here locally, is $310. And I typically have the parties just split that 50-50. Would that be something that you all would be interested in?
If we have to, then yes. My other concern was basically the childcare that she is put with in Greg's time with our daughter. When she goes to her aunt's, she is exposed to so many foul things. She comes back with regression in behavior. She's very sexually curious. It's not healthy for her. They do drugs right in front of her.
And again, so we don't have, if there's allegations of drug usage, then I'm going to request a GAL. That's not something that I have documentation of. So if you're requesting that visitation be limited because of significant safety concerns to the child, then that is something we would need a GAL for.
That's not what I'm requesting. I don't understand why she can't be with me instead of going overnight to someone else's house when I could provide her stability. It's
not your parenting time. That's why.
Can I say something?
Yes, please do.
Yes, I wanted to ask your suggestion because I know that she has a thing against her sister. I have addressed all these problems. I have actually gotten mad at her sister and asked this stuff, and her sister gets very defensive, says she doesn't do that she's willing to take a drug test, hair follicle test. I don't know what to do in this situation because the last judge that we spoke to said, Adeline was in her care for so long not to rip her away from her auntie. I have limited that she maybe maybe once a week, if that. Like sometimes she goes 3 weeks without even seeing her auntie. So it's like mainly it's just me and my mom, and that is, the best. That's how I like it. But I do, she misses her auntie. I sometimes, let her go stay the night there. I've addressed all these problems, and I haven't taken it lightly. And she, within responses, says anytime, hair follicle test, have somebody stop by, whatever. So I wonder if sometimes it's just something that's, because they're sisters and they don't like each other. But I don't know what to do in this situation. Yeah, the easiest thing would just be like, yeah, she can't go there. But, like, she's going to miss her auntie, and, she was a big part of her life.
All right, so I think I've heard enough. I've looked at the history of your case. I am a little confused why we've never had a GAL appointed. I see that you guys, that this matter was in guardianship proceedings for a period of time. I, on the court's own motion, am going to appoint a GAL because there are a lot of allegations going back and forth. I don't believe this is something that you all are close in agreement on, even if it appears that way on paper. I think there's significant safety concerns that are being raised for the child. What is the current age of your child?
4.
Okay. Who are the next 3 GALs? I'm going to read off 3 names, and then I'm going to see if you guys want to strike any of them, if you know them or had an experience with them. Ann Height, Twyla Corey, and Heather Cull. Do you want to strike any of those? Oh, I'm hearing no objection, so I'm going to sign Ann Height. I'm going to set some review dates in a minute, but first let's talk about payment. I'm going to ask you all a little bit about your income to determine if the county pays for this, you all pay for this, and at what portion. So Ms. Davenport, first, what is your monthly income?
Right now I'm currently temporarily on TANF. So I think it's 530.
Okay, so you're not currently working?
No, I'm taking classes to become a CNA.
And how much longer do you have in that program?
Probably about a month, maybe.
Okay. And then, sir, what is your monthly income?
I think roughly about $3,000.
Okay. And then is that before or after taxes? Is that your take home pay?
Yeah, I think that'd be about my take home pay.
How many people do you support on that?
3.
3 dependents?
Yeah.
Okay. So what I'm going to do is indicate that this will.
You have 3 kids?
Well, no, 2 dependents and 2 dependents.
But yeah, okay. So this is going to be county pay. What I'm going to do is indicate that 50% of it will be reimbursed by the respondent. And then 50% will be paid at at public expense. So that would mean the maximum the GAL can charge. Just going to get out my calculator here. In a county pay case is $1,485. So then the max that the respondent would be reimbursing at conclusion would be $742.50. The GAL is going to be, I'm also going to reserve on petitioner's reimbursement. We'll re-review if you do become gainfully employed before this is concluded. And then the GAL is going to be tasked with interviewing both of you about the concerns you have about either party regarding any issues of substance abuse, mental health, anything like that. We're going to do a 30-day review. So let's set that to, are the two of you free the day before Thanksgiving, November 22nd?
I think that should be fine.
Okay, so that'll be November 22nd at 9 a.m. Then the interim report will do. Let's do that, the end of, now let's bump that into January. Let's say January 7, 2023, 9 a.m. Oops, did I get that date wrong? Hold on. January 10th, I meant. January 10th. And then February 14, hopefully for the final report.
February, what was that?
February 14. So the next hearing will be November 22, 2023. So when Ms. Height reaches out to the two of you, please make sure you get back in contact with her.
Okay.
Any questions for me in the meantime?
So the guardian ad litem will be getting hold of us first. We don't have to reach out to her first, or?
Correct. She'll be given your contact information and she'll reach out as soon as she has the document and the order in her file.
Okay, and what's her name again?
Ann Height.
Okay,
Okay. All right. Thank you both. We'll see you back November 22nd.
thank you.
All right, thank you.
Thank you. I have us on for a review hearing. In the interest of time, I think I'll start with Mr. Lawrence and see where we need to go. I think I have one case besides yours to do, and I'm going to try and get everyone done in 7 minutes. So the buzzer is started.
Your Honor, my final report is due at the end of November. As the court is aware, Tanya and her husband moved to Texas, and the court allowed her to have visits as long as they occurred in the state of Washington. And she did exercise one of those visits just recently. And she is asking that the child be allowed to go to Texas for a visit as well. Mr. Perkins had some concerns about Ms. Johnson's current husband. His name is Trig Johnson. He is a truck driver, and I did a nationwide background check on him. And what I discovered was a fishing violation in 2012 and a theft in 1997. Other than that, he has several traffic tickets which are related to his profession. But I found nothing of any concern that would raise a red flag as to whether or not the child can go and visit its mother in Texas.
Mr. Perkins, so obviously we will, come back once we have the full GAL report, but it sounds like in the interim, Ms. Skelton is asking for approval for the child to visit her in Texas. What is your position?
I mean, my position has been and will continue to be at this point that he's too young to be traveling back and forth on an airplane, even though his mother will be with him. And her request for the frequency of the visits is also concerning to me.
What is the frequency requested?
According to our last conversation when she came up here to visit him, she would like a month on, month off visitations, which to me is just for his psychological and emotional well-being, not a good idea.
Ms. Johnson, what is your request of the court?
That was just a suggestion that I had, being that I went a month without seeing him face to face, and Clayton over video calls had gone from being very excited to see me to being not very interactive with me over the video calls. So I was just wanting to have a longer video or longer face to face visits with my son, if that was at all possible, instead of going longer times without seeing him. And that's why I was suggesting a month with him. And because it does cost quite a bit of money to go down there to get him or to see him, it would make it more cost worthy for myself to have him here for a little bit longer of a time period.
Okay, so, and just so I can understand the facts fully, he's 2 years old currently.
He is, yes.
Okay. And then when did you move to Texas?
About a month ago.
Okay, 1 month ago. And then up until the move to Texas, what did visitation look like?
It was about every other month or every other weekend. Sorry, Your Honor.
You had him every other weekend?
Yeah, Mr. Perkins and I were on an agreement about every other weekend.
Okay. So I think, I do think 1 month on and off, given the history with visitation, doesn't seem to make a lot of sense. That's not what the child is used to. I think that would be very disruptive to a 2-year-old. I am willing, it sounds like, just based on, temporarily putting a visitation order into place, I am willing to allow Ms. Johnson, you to fly here to get child and child fly back with you. Obviously, I'm not going to allow a 2-year-old to fly unaccompanied.
No, of course.
But I will allow it, but I'm not inclined to do 1 month on, 1 month off. I do understand the cost hindrance, though. My initial thought, and I'm open to input from Mr. Lawrence and the parties, I think given even before the move that he was only with you on weekends at most, but taking into account the cost and time encumbrance, I would be inclined to say, 1 week a month at most right now until we have the full GAL report. Mr. Perkins, is that something that you're comfortable with?
Well, I mean, the GAO report's due at the end of November, so I mean, I don't see why any more visitations can't wait until that comes out.
Okay, well, so my question isn't that. My question is if you'd be comfortable to 1 week a month until we make a final decision.
Yes, I can agree to that. I am reluctantly agreeing to it, but I'm
asking for your honest input. I'm just throwing out ideas here, so I'm getting your input.
Okay.
Go to the other parties. I'm not asking you to agree or disagree with anything, just whether you're comfortable with 1 week.
I'm not comfortable with it, no.
Okay.
I'm not comfortable with having my son that far away for that period of time. At this point, I feel that her main reasoning is not for his best interest. It's more for her best interest. And it's just not a situation that I'm comfortable with.
I understand you have been the primary parent at this point, so I take your input. Mr. Lawrence, what is your input for the court on this, just pending a final report?
Your Honor, we actually addressed this very issue when we set up parenting plans for summer visitation. Historically, the court will order 2 weeks of uninterrupted time. However, when the child is little like this, going beyond a week seems like a lifetime to this child and may start creating bonding issues with the other parent. And so at this point, I believe that if Ms. Johnson was allowed to have up to 1 week, that would be terrific. And then if she wants to come back up and visit with him within the confines of by the end of November, she would have 2 more visits with him. And that would aid me in seeing how the bonding is going as well.
Okay, thank you for that input. Ms. Johnson?
Yes, Your Honor.
Go ahead with your input just on this temporary proposal until we have a full investigation and report.
I'll do what I need to do. I mean, going down there for that many times is going to be very costly for me, but I mean, to see my son, I'll do what I need to do.
Okay.
I would love to get him here to visit me here, but I'll do what I need to do.
So what I am going to do, just pending our next review, which do we already have that set for the 22nd? Or sorry, the 29th? Looks like we do.
That's my understanding, yes.
We do have a review hearing November 29th. So just between now and then, I'm going to do a temporary bench order that does allow you, Ms. Johnson, 1 week to fly your child accompanied to be with you in Texas. That will be up to 1 week a month. I know that's probably not feasible every month, but that is going to be my order. I take into account what the child is accustomed to. And I think I'm even pushing the envelope a bit with what the child is accustomed to with weekends with you. I also take into account that it was your choice to move. So, you know, that is something that the court has to look at. The visitation in Washington is still an option to you. So in between the visits in Texas, if you want to come up here and engage in the visitation that's already been put in place where you are present in Washington without taking the child out of state, I will still leave that in place. And then we will re-review this matter on November 29th. I will put into my order that the week with you in Texas does need to be coordinated with Mr. Perkins. So it does need to work for his schedule. I do anticipate that there could be issues that come up with the two of you working on what week that could be or should be. But I'm going to encourage you, at least at this point, to work together on that. But I am going to put in the bench order that Mr. Perkins needs to agree to the week that you've picked. So it can't be a scenario where you just tell him what your flight details are. It needs to be something that he can also make work as the primary parent currently.
Of course, Your Honor.
Okay. And then we'll be.
Your Honor, may I add something?
Please do.
What, with this order with him going to Texas, if she decides to keep him, what's my, what options do I have as far as recourse of trying to get him back?
Well, you're going to have a visitation order that only allows him to be 1 week in Texas. There would be criminal implications if a non-custodial parent does not return a child after visitation. So probably, you know, you would have the ability to contact law enforcement at that point.
Okay, thank you.
Yeah, you would. Yep. Yeah, you will have an order from the court limiting the visitation to 1 week out of state. Okay, anything else we need? Otherwise, I'll see the parties back on November 29th.
Nothing for me, Your Honor.
Okay, thank you all. Thank you, Mr. Lawrence.
You bet.
We'll start with number 1 on the docket as Ms. McNeil is present. That's State of Washington versus Kayla McNeil, 22-300-11908. Ms. McNeil was not present at her last review on October 4th. That was an early review to check in on her compliance. We have not received any information regarding the substance use disorder or mental health treatment plans that she's been required to provide. We have not received a substance use disorder compliance report or any information regarding whether or not she's contacted alternative solutions. We've also not received a job search work log, which we have previously stated would include any treatment that she was attending. That is just a simple form to fill out, which should not be an issue. She can email that to Mr. Angelico as well as any of the other information. At the last review, we were informed that she was supposed to have had an assessment on October 9th. Someone was filling in that day for Mr. Angelico, so they did not have information as to what that assessment was for. So the state would inquire as to what that assessment was for and whether or not it had been completed.
Thank you, Your Honor. I can address parts of those issues. One is we did receive, and I didn't forward this because there is I think it's HIPAA protected, but basically I did receive from Cowlitz Family Health Center the fact that Ms. McNeil had an appointment and did have an SUD assessment. They sent a letter dated October 24th that said she completed the assessment, that she needs IOP level 2.1 treatment, which normally is the 3 times a week, that she's scheduled to begin those appointments in those groups on October 31st. At 4:30 would be her first group. And that was signed off by the SUD provider, was Heather Temple, the Cowlitz Family Health Center. So apparently she is going to be in SUD groups. We would ask Kayla a couple of things. I know that she had contacted me and had indicated when she had contacted Alternative Solutions. Kayla, do you remember when that was?
I don't exactly. It was I know it was a couple weeks ago, but they haven't called me back. I've just been waiting to hear back from them.
And I know that she did contact me, and I can try to pull up the date, but I do know it was probably several weeks ago when I either was working at home or someone else took the message, but I believe she did contact them. As far as job search work log, what have you been able to do, Kayla?
I need to get it emailed to you. I filled most of it out. I had a couple more things logged down. I was going to get it sent to you.
And remind the court, you've had issues with, I believe you're type 1 diabetic, is that correct?
Correct.
And you've been having some issues with the diabetes. Have you had, my understanding was, were you having dental work done?
Having what?
Were you having any dental work done?
Not dental work. I needed to, well, I've had a couple eye appointments. I'm going to be getting eye surgery. And other than that, I haven't had any dental work though.
Okay, and are you able to either forward in the job search work log, or even if by phone you can make?
I can send it to you today.
Okay, thank you.
Mm-hmm.
Your Honor, we just inquire about the eye surgery, if that was something that Ms. Mina was stating was a barrier to her being able to seek employment.
I wouldn't know the answer to that, Your Honor. Ms. McNeil may know the answer to that. What type of eye surgery is it?
They're gonna be scraping something off my right eye and then doing lasers on my left eye. I just recently found this out, though. I found this out last week.
And who's doing the work? Who have you seen for the
Eye Institute?
KCI Institute?
Yeah.
Okay.
Ms. Looney, based on that information, what would be your recommendation and next review date, or your request, excuse me?
So, Your Honor, at this point, our request would be that Ms. McNeil had previously stated she was also going to be doing a mental health evaluation. If that was recommended by her intake or by her counselor at Cowlitz Health, I believe that was who she had seen previously, who had recommended it. We would ask that she be required to follow through on that evaluation to see if she needs treatment regarding any mental health concerns that may arise. We would also ask for confirmation from the KCI Institute regarding eye surgery and recovery time that may be needed from that. We would also ask that she reach back out to Alternative Solutions. I know they are busy. I have been in contact with them. I'm trying to work out a way to have someone specifically for our county to work with our contemnors, and I will inform Mr. Angelico and yourself, Your Honor, about that after the docket. I just did want to mention that to hopefully streamline the process in the future. So we'd ask that she just does reach back out to them in the interim to confirm whether or not she would be able to be screened in for help with their services. And her next regular review would be the 4th week of the month. So that would be on November 22nd.
And I know that one of the issues that we've had when we've told people to contact Alternative Solutions is they haven't figured out, and I don't believe that they have a way to track and to be able to send somebody confirmation that they've contacted them. So it's kind of, I've had this happen 2 or 3 times where they said they've not called back, and there's nothing that other than to call them. There's nothing to show that they called them.
Right, which is why I'm working on trying to find a different process.
Okay. And that was November 27th.
22nd.
22nd, thank you.
Yes.
November 22nd. So Ms. McNeil, we'll have you back on November 22nd. Stay in touch with Mr. Angelico so you can start marking some more of those things off the list of what the state would like to see, okay?
Okay, thank you.
Any questions before we let you go?
No. That's it.
Okay, thank you for being here.
Yep.
And then I think just one more, Ms. Sager, 223-00-23308.
Yes, Your Honor. This was in a review just sent over from last week because there hadn't been a payment made yet for October, and it wasn't clear if Ms. Sager was still employed. Since that time, she has had a payment post to her account through a wage withholding. So it does appear that at least as of October, she was still employed. Her employer has not been very good about sending their payments in regularly. So I know that DCS has been in contact with them as well regarding that. At this time, we are not asking for any additional purge conditions, just that if she's unable to pay for the month of November, she provide a job search work log, and her regular reviews are the 3rd week of the month. So her next regular review would be on November 15th.
And do you know what date the payment from the employer posted?
It posted on the 20th of October.
And you said next review date, November 15?
Yes, Your Honor.
Okay, we'll go ahead and set that review. Anything else we need to do on this docket?
Nothing further from the state, Your Honor.
I do have possibly one question, Your Honor. Let me take a look at. You know, if the payment did come from the employer, or did it come from Ms. Sager?
It was noted as from a wage withholding. It did not note that it was from a self-payment method.
There's a payment that she noted, and it could be the fact that she was trying to say it was from an employer, but the email I received was that she had made, when she couldn't appear last week, that she had made a payment yesterday for the $500. So it was a little confusing if it was from her or from employer. I'll reach out to her.
Yeah, according to our records, it is through the employer's wage withholding. And so she is paid in full for the month of October at this month. So she wouldn't need to make another payment until November at this time.
And is there previous payments is this a consecutive payment from previous?
I believe so. I just didn't write that down specifically. Let me check her file. Yes, so that would make her paid in full for 4 months at this time. Sorry, I neglected to note that.
Okay, thank you.
Okay, we'll note the 4-month payment history. Anything else based on my review of the file? When we were last together on September 6th, it seemed to be going very well, and we were expecting agreed orders to be presented. That hasn't happened, and now I do see that Mr. Hart has filed a motion to restrict visitation and re-review the GAL findings. I haven't yet seen a response from Ms. Hart. I can't tell if she has been served that motion or not. Ms. Hart, did you receive Mr. Hart's motion to restrict visitation?
Yes, I received that. And
It's very hard to hear you. I'm not sure if you can turn up the volume somehow.
Is that any better? I can talk louder.
Mr. Hart, I don't know if that's from your end. There's just a lot of feedback audio.
It might be. Let me see.
Yep, that is you. So no, it's not you. Ms. Hart, is that on your end?
I don't know what it would be. I don't have anything going.
I can. Wait, hold on. I'm going to mute you just to see if it is you. Hold on. Yeah, it is you, Ms. Hart. So hold on one sec. I have you muted, Ms. Hart. I have you muted. There's a ton of audio feedback that's making it difficult for us to hear anyone else. And I can barely hear your voice. So I'm going to have you stay muted just for a minute. I think what I've heard you say is that you did receive the motion to restrict visitation. So I am going to come to you in just a minute, but because of your audio issues, I'm going to have you hold tight for just a minute. I'm going to go to Mr. Hart and to Ms. Call. So Mr. Hart, it sounds to me like we don't have agreed orders. You have some new concerns and you want those looked into. Does that sound correct?
Well, the parenting plan orders we pretty much agreed on it. There was just a couple of errors that needed to be fixed on dates where Eric lived. And that was pretty much the only thing with the parenting plan. It just some errors needed to be fixed. But other than that, we agreed on everything. But the issue, my main issue is that well, it was a couple of weeks ago now, my son came home and like while we were talking about what was going on, at one point he was like, if I'm going to be spending the night at mommy's house, how do I do that if I'm not supposed to be around Kevin? Because it said in the GAL recommendations that Kevin Johnson was not supposed to be around my son. And I just assumed that the GAL recommendations was basically the court's findings because that's what she's hired to do. And when I brought this up to Catherine, she basically just said, like, I talked to Heather and she said it was basically fine. And she said I could bring this back up in the court if needs be. And so I'm just needing her to follow the rules because like we were getting along and everything was going so well because everybody was just following the rules and doing what they're supposed to. And then when I found this and like, it's not like she disclosed that. I found it out from my son like a month after he had started going over there. And so that's just my main issue is that it said in the paperwork not to be around. And it was very, very specific, you know, and then I find out that like, not only is it around, but she didn't tell anybody.
Okay. Let me go to Ms. Call. Ms. Hart, I will come to you. It's difficult to hear you, but I will come to you next.
Good morning, Your Honor. So Mr. Hart is correct that I did in my recommendation state that no unmarried romantic partner should be, should Eric have access to at this point. My only reason for that is because this is such a sensitive situation with Eric, and we know that dramatic change for Eric is very difficult given some of his diagnoses and some of the things he struggles with. My particular concern around Mr. Johnson is a very long history, specifically with Ms. Hart, with domestic violence as well as very serious substance abuse. At this point in time, I want to applaud Ms. Hart because she's really done a wonderful job on her sobriety. She's doing a wonderful job coming slowly back into Eric's life. And I can respect and appreciate the fact that Ms. Hart is excited to fully integrate Eric into her world and have him be back in her life. But we also know what we know about Eric is that going at a slow pace and doing this in a way that's healthy for him and with the support of his mental health professional and with the support of Mr. Hart and his wife, whom Eric has been living with for the majority of his life. I want to respect Mr. Hart's wishes that this timeline be respected in a very specific way. I also understand Ms. Hart has moved Mr. Johnson into her apartment, so I can understand that there's a desire here for this all to happen at once. But it is my recommendation that is not the healthiest path forward for Eric. And I have very serious concerns, given that Ms. Hart, I believe, has just hit her sober birthday, if I'm correct in that, for a year. And I respect and applaud that. But I think we need a longer history of sobriety for both of these people before Eric is put in a situation where he needs to adjust to not only these new relationship standards with Ms. Hart, but also with this other person in her life who he doesn't know and doesn't have a history with.
I'm just looking here at the report, Ms. Hart. I'm going to come next to you. So it sounds to me like, as far as the parenting plans, we're still kind of working through that, and I can give you all new dates for that. But the most immediate pressing issue appears to be your son coming to your home now that Mr. Johnson appears to be living there. So what can you tell me about that, Ms. Hart?
Mr. Johnson has been sober for over 2 years. I submitted all his certificates to both the court, to Mr. Hart, and to Ms. Call. He's been clean and sober for over 2 years. He completed the drug court program in Clark County. I turned in his parenting class certificate. He completed the 52 weeks of the DV and anger management classes. So he's, I am coming up on my sober birthday here next week for 1 year, but Kevin has over 2 years. He's been at his job for almost 2 years. The reunification process between him and I, it was a process as he completed all of those classes and everything. Eric has been.
When did Mr. Johnson move in with you?
Around the beginning of last month.
The beginning of last month. So were you aware of the court's adoption of the GAL recommendation that your child not be exposed to unmarried romantic partners without consent of the other party?
I don't know about consent of the other party part, but it was after court. And Heather was aware that we were seeing Kevin, that he was coming up on weekends at that point. And I also kept her aware of his progress. So it was after our last court that he had moved back up. It was after he completed all his programs.
Okay, but also you're talking a lot about his sobriety. What I'm concerned about is his felony DV arrests. So that's a huge concern, ma'am, for the court. I'm actually just a little bewildered that you thought this was an okay path forward, saying, well, it happened after we went to court. So, I mean, we don't have permanent parenting plans in place. This is all still very much an open family law case. And I guess I'm just trying to get from you why you think this is appropriate for your child, because I don't.
I don't know what to say. Kevin and I have a 3.5-year-old daughter together, and he's completed all those classes so that our family could be unified again. And Eric is a part of this family.
So he was arrested 2 years ago, almost exactly, for felony no contact order violation of an unlawful imprisonment DV.
And that's what he completed. They entered him into the drug court program to take care of that, and that's why he went through that program. And
Can you understand why Curtis Hart has concerns about his child being in this environment?
Yeah, I do understand, Mr.
Okay.
Hart. I told him even, like, I understand, like, looking at the record, I would also have those concerns.
I can't, Ms. Hart, you're going to have to speak much louder.
I understand Mr. Hart's concerns. And that's why I tried to show him all the progress that had been made and everything that had been completed on Mr. Johnson's end.
Okay. Ms. Call, I am troubled by this. This is very different than what was presented to the court by Ms. Hart when we thought things were all moving forward. I understand Mr. Hart's concerns. I personally am very concerned. I also don't want to, I mean, normally what I would do in this situation is essentially terminate visitation until we work this out. I don't want to do that. I think this child has been yo-yoed enough, but I don't know what else to do with these concerns with a very recent history of domestic violence. Significant. We're not talking misdemeanor domestic violence. We're talking felony domestic violence.
Your Honor, I share those concerns, and the DV case was actually against Ms. Hart. She was the person involved with this issue, and she and her daughter essentially fled her relationship with Mr. Johnson. And when I first visited with Ms. Hart, and she did share with me she was having digital visitation with Mr. Johnson because he is her daughter's father. And I had asked her specifically, and I wrote about this in the report, if she was still engaging with Mr. Hart. She said she was. And that's what led me to make the recommendation that Eric not have to have a relationship with unmarried romantic partners, specifically because of the concerns that you're bringing up, Your Honor. I have very serious concerns about this as well. At this point in time, I think it would be very hard on Eric to go back to not being allowed to see his mother. And I have concerns that Eric would not understand why that's happening. But I do think either a once a week visitation or even a supervised visitation may be appropriate until Mr. Hart feels that there is enough trust established that Eric can safely be in this relationship. It is true that he has a younger sister who I think he should have access to. They have a bonded relationship that I think is valuable. And I do believe that a bonded relationship with his mother going forward is appropriate. However, I think that at this point in time, we need to see that that's going to be a healthy and an appropriate relationship in a way that's safe for Eric.
I agree. Mr. Hart, what is your hope here? What are you feeling comfortable with?
Well, I feel like I agree with the whole like unmarried partners thing, at least for like, like I would imagine like 6 months, because he doesn't really know his mom yet. Like he's just getting to know her. And it's for those specific reasons, like everything you were talking about, like they had to crawl out of a trailer window with her baby, according to the paperwork.
Yeah, I understand.
And that's like, I just don't want my son to ever have to be put in any type of situation where a stepchild annoys a stepfather, and so like, I also don't want him to not be able to see his mom because he's doing very well. Everything's going very well. I was under the impression, like I've been told by Alice, that Kevin has a mom, like he can just go to his mom's house and not be there. As far as I'm concerned, like he could still totally go and hang out there as long as Kevin's not around. Like I thought that he wasn't. And if he's not there, because Eric's in this school program where he's going to like in a leadership club, and so he needs to get like a different ride besides the bus in the morning. And so he was going to be going over there on Wednesdays. We switched it to Tuesdays so that he could spend the night and then go to school from her house because she's just right down the road from his school. And she came and she picked him up this morning and drove him over there, which is great. But like, I'm like, if Kevin's just not there, like I'm fine. I just need the courts to tell me that he's fine. If he's fine, if he's not fine, I don't really know what to do.
Ms. Hart, my inclination is to issue a bench order that allows you the continued visitation as is, but the stipulation is that Mr. Johnson cannot be at the home when your child is there. Can you make that work?
I'm sure between me and Mr. Hart, we can figure something out. That's what we've been doing. And Mr. Johnson works full time, so a lot of times he's at work anyway.
Okay.
So I'm able to figure something out until maybe we are able to get this reviewed again once, I don't know if he's reappointed and she can look into, I don't know, verifying his, completion of classes and everything that was required for him to come back with me and my daughter.
Yep, I think that is a good idea. What I'm going to do now, we'll set a review date on this to allow Mr. Hart. I don't, Ms. Call, are you at your cap with this case? I'm not sure where you're at.
I am. I'm beyond my cap. It's a county pay case. I actually went beyond the cap on this case, but if Your Honor feels it appropriate for me to remain involved, I'm happy to do so.
Okay. I am, and I will approve additional hours and monies for this case. I think it's important in this unique scenario, and you can send that any type of request for fees directly to me, because I know why I'm making this ruling and why I'm requesting additional hours. It is for the safety of the child. I'll know specifically with felony DV cases, typically there's a 5-year probation period where a court is monitoring. So I really am just not comfortable right now with anything other than what I'm going to order, which is at least until our next review, that Mr. Johnson not be present when the child is visiting Ms. Hart. How far out do you all want to review this?
Well, Your Honor, given that we're coming into the holiday season, and I will confess my caseload is quite stacked at the moment. If we could get into the new year, I know that's a long wait. I know it's a ways out, but I want to be sure that I can actually give this case my attention.
Yeah.
If it's possible to get into January, that would be very helpful for me. I assume at this point, I'm going to need to do some interviews with Mr. Johnson and spend some time with Eric. And so I just want to make sure that I can do the appropriate investigation.
Yeah, I'm thinking January, let's get us a little bit past the new year, January 10th. Would that work for the parties? That'll be a Wednesday. Well, are they keeping this docket Wednesday at 9 a.m. in 2024?
Well, and just so you know, Your Honor, I do have a review hearing that morning in Clark County.
Okay, so we'll pick a different date.
I'm available on the 17th if that works for everybody else.
When will it be?
Wednesday's 9 is supposed to be.
Oh, it is still going to be. Okay. For now, if we change, 2024 brings in docket changes, we'll certainly advise the parties. But for now, let's set this review for January 17, 2024. I wrote 2023. 2024 at 9 a.m. That'll still be the Wednesday Zoom docket. And then I know we had the orders, the agreed orders. I would probably say, that the court is going to want to see this further investigation before we do any sort of final orders. So I would hold tight on those for now.
Okay. And would Your Honor appreciate an amended report, or would you just like a verbal review?
I'm fine either way. Probably I'll leave that to your discretion, depending on how in depth, the interviews go and the information you need to get to the court, but I'm fine either way.
Okay. All right.
Okay. We'll see you all back on January 17th. Anything else the parties need from me?
I don't think so.
Okay. All right. We'll see you back on January 17th. You're free to log out.
Thank you, Your Honor.
Thank you all.